On behalf of Russell Exelby.
This courtroom opens quietly, but what unfolds here is anything but small. You're about to watch a judge dissect addiction, responsibility, and public safety in real time. This case isn't just about someone slipping up and having a drink. It's about what happens when the court gives you a second chance, and what it means when you break that trust. Russell Exelby stands in front of Judge Simpson after violating conditions meant to keep him sober. He's already been given structure, already been warned, already been placed under supervision, and yet, he still walked into a situation he knew he wasn't allowed to be in. The defense frames it as a mistake. The court sees something deeper, a pattern. And this isn't happening in isolation. You're about to witness multiple defendants, multiple decisions, and one common theme: what the justice system does when people keep pushing the line. From alcohol violations to disappearing defendants, from drug admissions to bond revocations, every ruling in this courtroom sends a message.
Your name, sir?
Russell Exelby.
All right.
Good morning.
Good morning.
Today's date for a PCC and a violation.
Yes.
I've talked to Mr. Exelby. Mr. Exelby went over to his friend's house and was drinking, despite the fact he's not supposed to be drinking. You're admitting to that, correct?
Yes. Made a mistake, a big mistake.
He is now being treated. Where are you going for
A Stillwater counseling.
Stillwater counseling now? And I've advised him in the strongest terms to stay 100 feet away from even a sign advertising alcohol. I would hope court would let him out.
Okay. Well, first of all, what are we doing with the case?
We're going to need to adjourn PC. There is an offer that I need to explore with him in some detail and further talk with Ms. Landy.
As to then, what I will do is I'll adjourn the probable cause conference to December 5th.
Is that good, man?
She's looking. Offer back. Hey, we didn't even look at you when I put the date. I looked right at her.
So I noticed.
Oh, Pete.
Stay the hell off the phone too. Don't talk on the phone.
She's the 12th.
The 12th. December 12th, 2024, 9 a.m. All right. As to the violations.
I do understand the defendant is admitting to drinking. The concern of the people, I'm sure, as the court recalls, as we were here, this is known to be why the defendant had been placed on a SCRAM alcohol tether to continuously monitor any potential alcohol usage. We had an alleged tamper where the defendant, through counsel, asserted that because he's a farmer, the socks were interfering with the tether.
I remember.
And requested, to be placed back on the at this point, people would have requested if there is going to be any release, the defendant remain on a SCRAM tether for the duration of his bond, as long as this court has control of those conditions.
I look at it this way. I think the whole thing about it interfering, the SCRAM tether interfering, while Mr. Vincent made that argument in good faith, I think that was the defendant trying to do something else.
May I stand mute to those charges, Your Honor?
I understand. And
I
I'm not.
understand that as well, which is why I say he's making that argument through his attorney. I understand.
So I will give him a bond because right now he's sitting with no bond. I'll set his bond at $50,000 cash or surety, but I'm not releasing him. And if defendant is released, defendant has to have a SCRAM tether prior to release.
This is the sound of trust collapsing. Judge Simpson doesn't explode. He doesn't lecture. He simply recalibrates reality. $50,000, cash, and even then, no release without a SCRAM tether. A SCRAM device isn't symbolic. It's invasive. It monitors alcohol in real time through the skin. It exists because the court no longer believes words, only data. And watch how quickly negotiation dies in this room. The moment defense asks for 10%, the judge shuts it down. That's not ego. That's authority reminding everyone who sets boundaries here. Never negotiate against yourself. That line is a legal philosophy. Once you weaken your own ruling, you teach people how to push you. This ruling tells Russell something clear. You are now classified as a risk. The court is no longer betting on your promises. It's protecting itself and the public from your choices.
Would the court consider a 10% on that 50,000? One would hope.
You know, every time I say something, he then wants me to change my mind. So that's that whole idea of negotiating against oneself, right? Back when I was a wee attorney and Mr. Vincent was helping me, Mr. Vincent always told me, never negotiate against yourself.
I'm not negotiating, I'm
So-
begging.
I'm going to take the lesson he gave me. No, I will not consider 10%.
I apologize, I couldn't hear. Was it 1-5 or 5-0?
5-0.
5, thank you, Your Honor.
How much? It's $50,000 cash or straight. You gotta call a bondsman, okay? And brother,
No, no, so I finally found somebody older than me.
That goes with construction.
Oh, that goes with the file. Thank you.
Not really ready, Judge. Tori Feaster, Assistant Public Defender on behalf of Mr. Al Perez Zacharias.
People, please, on behalf of the people.
Thank you, Judge. I did speak to the client. I don't see him here, Your Honor.
He's not here?
I've asked everybody in the courtroom if they are him, and they've all told me no, Judge.
And everybody denied it?
Yes, Judge.
Okay.
I did speak to him by text message yesterday, telling him to come to court and telling him to go to community corrections immediately to test. Because my understanding is he had not tested, Your Honor.
That's right.
He indicated this morning that he was there testing by text message. But
That he
now-
was at community
that's what
corrections
he said
testing?
At 8:30 this morning, but now I can't find him.
So, and then where'd he go?
I never saw him. At 8:31, I received a text message. I'm doing my test right now. So he said he was here doing his test, but I never actually laid eyes on him, Judge.
And he didn't want to come across the street to come see us?
Apparently not, Judge.
Hmm.
For the record, I request an adjournment, but I do not. know
Really?
why he's not here, Judge.
How well do you think that's gonna?
I have pretty good idea how that's gonna go. But I wouldn't be doing my job if I didn't act.
Yeah, you're right. Bench warrant will issue for defendant's failure to appear. Bond will be setting him on a $25,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
This is the moment where absence becomes a crime. The court doesn't chase excuses, it responds to behavior. When a defendant doesn't show up, the system interprets that in one of two ways. Either you don't respect the process, or you're actively trying to avoid it. Both are dangerous. Notice how little debate this takes. No speeches, no warnings, just a bench warrant. That's because court operates on one sacred rule: presence. If you don't appear, everything else becomes irrelevant. The defense tries to explain, text messages, testing, confusion, but the court doesn't work on probably. It works on here or not here. The courtroom is binary. You're either standing in front of the judge or you're not. And that's why Judge Simpson doesn't hesitate, because once you allow non-appearance without consequence, you teach people that court dates are optional.
So if he's there, he's at community corrections, then let him know. They'll bring him. Court calls the case, People versus Patrick Lay. 2 cases.
Good morning, Your Honor. Mike, on behalf of Patrick Lay. State your name, Judge.
All right. You're requesting an adjournment.
Yes, may I also, at the appropriate time, address his bond?
I want so bad to say no. I will adjourn probable cause conference to December 12th, 2024 at 9 a.m. Yes, Mr. Vincent, as to bond.
I'm going to talk to my client here for a minute. Mr. Lay, Judge Simpson asked you the last time you were in front of the judge, when's the last time you used meth when you got picked up driving the moped? When is the last time you used meth on that day?
On that day, sir.
On that day?
Yes, sir.
Tell the judge when you were using meth.
That was the last day that I choose to use, was on the day that I got picked up. Your Honor.
That's not what you told me, though, right?
No, it was not.
You lied to me. Right?
Yes, I did, and I'm ashamed of that, Your Honor.
This exchange cuts deeper than any bond ruling, because here, the court isn't reacting to a crime, it's reacting to dishonesty. Judge Simpson doesn't accuse. He states, "You lied to me." And the defendant doesn't fight it. He admits it. That admission matters, but it doesn't erase what it reveals. When pressure hits, this defendant chooses deception. Courts operate on information. Judges make life-altering decisions based on what they're told. When that information is false, the entire system becomes vulnerable. That's why this moment feels heavier than the meth itself. Drug use is a condition. Lying is a character signal. And notice how the judge responds. Not with rage, but with recalibration. He begins asking about treatment, structure, parents, support. He's still trying to build a framework that might work, but now it's cautious.
I just got involved in this case and I did not have a chance to explain to him what needed to be explained. And I'll leave it at that. Okay, you understand what I'm saying?
Yes, sir.
Good young man, just
Is he in any type of treatment at all?
he has parents who can afford to put him into private counseling. He also will take advantage of the community corrections program, but I think it takes a while to get in there. But I think his parents can come up with something from what I've been informed.
Well, what I'll do is I'm going to continue his bond as it's set right now. But if something can be put together, get to the prosecutor and get it to the court, I'll take a look at it and consider his release under some structure such as that.
We'll do that.
All right. But at this point, bond will
Have your
continue.
parents call. Don't talk.
All right. Thank you.
Don't talk on the phone other than your parents.
Your Honor, at this time, we wish to set the third exam.
Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 half. And I need to request this. That is the request that we made at the time we charged it, and my position is that his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was released, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his bond posted, arranging his pickup at a gas station near the jail, the two of them talking about how to get the no contact order dropped, about how they can have contact with each other once.
This is where the case transforms from procedural to alarming. These calls aren't casual, they're strategic. The defendant isn't just violating bond, he's actively trying to dismantle the safeguards protecting the victim. A no contact order exists because the court believes contact equals danger. And here we hear about coordinated planning, workarounds, manipulation. What makes this chilling is the intent. He's not confused, he's not impulsive, he's methodical. And then comes the twist. He doesn't stop at himself. He helps another inmate violate their bond. That's not desperation. That's leadership in misconduct. In legal terms, this shows patterned disregard. In human terms, it shows someone who doesn't believe rules apply to him. Audience, ask yourself, at what point does a mistake become a strategy?
So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Fickner is the person that participated in that, and he's the one that called her victim. Or excuse me, Mr. Gates' victim. So in regard.
So he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
Correct. Thank you, Your Honor. In regard to the facts of this case, the defendant, and I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle. While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast. And then when they got home, she watched as he was choking her mom.
This is the heart of the case. Not bond, not procedure, not phones. A child watching violence. Every word here carries weight. An 8-year-old describing fear, a mother being attacked, a car in motion, threats of death. This is why judges take domestic cases so seriously, because lethality escalates fast. Strangulation is one of the strongest predictors of future homicide. Courts know this. The courtroom goes quiet because everyone understands. These aren't abstract allegations. These are moments that stay with people forever. Audience, imagine being that child. Sitting in a car, hearing someone say they're going to crash it. Watching your mother be hurt. Now ask yourself, if the system doesn't intervene here, when should it?
The victim is that child's mom who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle began to strangle her. The victim reported separately from the interview with the child, reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently cooperating that. As I mentioned earlier, he had consumed alcohol and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground. The mom also was interviewed separately. She said that she saw the victim push the defendant and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V shape. They put in the report as a blood blister near her trachea. And those are the injuries they observed of her. So just based on the facts alone of this case, I am reviewing my office's response to cash surveys that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had with the victim after the agreement, and order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
Response.
Thank you, Your Honor. Our ultimate request is to keep bond set as where it is. As to the allegations of this case, I will just point out they still are allegations. And in upon review of discovery, My client does maintain that a lot of what is in the report is incorrect. As to the jail calls, that is correct. Ms. Hughes did.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's release from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Fainer has been out for, I believe, how long have you been out since posting your bond?
Last week, Thursday.
Last week, Thursday. So exactly 1 week, Your Honor. To my understanding, in that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court. And he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
Given the facts of this case, or at least as they're related to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high lethality.
Judge Simpson isn't disagreeing. He's correcting. When he says abuse of discretion, he's acknowledging that the system failed once already. This isn't anger. It's accountability inside the judiciary. He's saying this defendant was underestimated. High lethality, hospitalization, children present, contact violations, facilitation of others. The judge connects the dots. Behavior inside jail predicts behavior outside. And what he sees is someone who escalates when given freedom. This is when the court shifts from hope to protection. Ask yourself, should a system prioritize second chances or safety?
The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then that after all of this occurs, and what causes the court a great concern as to the defendant's conduct is that there are these contacts that aren't supposed to be contacts. While he's in the jail, that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's phone privileges, he facilitates, not only does he violate a condition of his bond, he then facilitates another inmate violate the bond in the case, or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it, Mr. Allen. Defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded.
This is final. Not dramatic, not loud, just absolute. Bond revoked. Phone privileges revoked. Freedom paused. This isn't revenge, it's risk management. The court is saying your choices have removed you from the category of manageable. Every prior warning echoes here. Every lie, every call, every violation. And notice, the judge doesn't debate. He concludes. That's what happens when evidence becomes pattern. Audience, was this inevitable? What you just witnessed is the justice system doing what it's designed to do when trust breaks down. In one courtroom session, we saw addiction framed as mistake, dishonesty exposed, absence punished, and violence laid bare. Judge Simpson didn't just rule. He evaluated risk, credibility, and human behavior. Russell's violation showed how fragile second chances are. The missing defendant proved that court orders only matter if people respect them. And this final case revealed why bond conditions exist at all, to prevent harm before it happens. The defendant here wasn't punished for allegations alone. He was remanded because his own actions, his calls, his planning, his disregard, demonstrated danger. This is what high lethality looks like in legal terms. It's not theory. It's children in cars. It's hands on throats. It's systems trying to intervene before tragedy becomes permanent. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.